In the matter of BHP Coal Proprietary Limited and Schmidt, the full bench of the Federal Court reconsidered an unfair dismissal decision of Commissioner Booth. In this particular matter, an employee of BHP, Mr. Schmidt, had been on duty when he had damaged a fuel tank. He hadn't originally realised that he'd damaged the fuel tank, but was notified by some other employees. He then tried to contact his supervisor, but was unable to do so because he was at the bottom of a pit. So Mr. Schmidt tried to contact his supervisor, but was unable to do so due to reception issues. Later on, he texted a mobile phone number that he thought was his supervisor's and notified that he had caused some damage to a fuel tank, along with the fact that he had a physio appointment that he'd forgotten about. It was later revealed that this was an old phone number, and in fact the supervisor had never been notified. When Mr. Schmidt spoke to his supervisor later that afternoon, he did not raise the damage issue, and he also didn't follow procedures in terms of closing off the area where the fuel had leaked. An investigation then took place where Mr. Schmidt was given an opportunity to respond as to why he hadn't notified his supervisor and why he hadn't followed the safety procedures. Ultimately, he was terminated and brought an unfair dismissal claim. The unfair dismissal application that he brought claimed that he had been unfairly terminated because he had in fact tried to notify his supervisor, and that he had offered to undergo retraining and was a long-term employee. Commissioner Booth, in the first instance findings, found that it was an unfair dismissal due to the supervisor having a closed mind when he considered whether or not Mr. Schmidt should be terminated.
It's one of those very unusual, or quite unusual cases where the full bench finds that an error of fact made at first instance was so significant that it actually constitutes an error of law, because the full bench doesn't hear the witnesses, doesn't have the opportunity to do that, but will look at the transcript and consider the evidence, and if they find that there's actually been a finding which was not reasonably open on the facts, they will overturn it, which is quite unusual in this case. But a lot of that was based on the fact that the full bench just couldn't find any basis in the evidence for the finding that the supervisor's mind was closed on the issue or predetermination, and in fact it was never put in cross-examination to the supervisor that he had already determined the matter.
Yeah, and also the full bench found that when investigating misconduct, an employer doesn't have to investigate with no leanings or inclinations or some idea as to what the outcome might be. They have to come with an open mind and give the employee an opportunity to respond and actually consider that response, but they don't have to come with such an open mind that they have no idea what the outcome might be at the end of the investigation.
And I mean, that is an error I think people often make in relation to considering workplace matters. Yes, there is an obligation of procedural fairness, but the employer is not in the position of a court or a royal commission with all those obligations. You can't help but in a normal day-to-day workplace to have some leanings or thoughts or feelings. You're not some kind of decision maker with obligations in relation to bias and so forth, the way a court would operate, or even an administrative decision maker. You're just a human being operating in the workplace. The issue is that you've got to give procedural fairness to people before decisions are made.
And I think a lot of people, when it comes to looking at termination, feel that they're very much just going through the motions, that perhaps they do have an inclination as to what the decision's going to be. But the important thing is, you do go through the process, and there is a proper opportunity for that person to respond and for you to consider that, even if your initial inclination ends up being followed through.
And probably from my experience, 80 to 90% of the time it does follow the course you're expecting, so that it's not unusual to have the leanings. However, there's always that 10%, 15% where something absolutely out of left field emerges so you wouldn't have considered, which is why procedural fairness is so important.